Does additional information void notice given under RPAPL 1304? To find out, you have to read Bank of America versus Kessler. It's only 12 pages. Don't have time for that? I got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals cases in 5 minutes or less. This is the episode on Bank of America versus Kessler. This can be found at 2023 New York Slip Opinion 00804, published by the Court of Appeals on February 14th, Valentine's Day of 2023. This is a civil case, and the issue here is statutory interpretation of real property actions and proceedings law, which in the legal field we call the RPAPL. This is interpretation of RPAPL 1304, and whether or not additional notices can be included with the notices required by RPAPL 1304. So to understand this case, I have to give you a little background. In the last Great Recession, there were a variety of problems that the legislatures identified with borrowers and lenders communicating about defaults of mortgages. And as a result, hundreds of thousands of people lost their homes and were foreclosed upon. So to correct that problem, the New York legislature passed RPAPL 1304, which says that before a lender or an assignee or a mortgage service provider can commence a legal action to foreclose upon a borrower, at least 90 days before they do that, they have to send out an RPAPL 1304 notice. And the notice has to include a variety of things, which are listed, including how many days the borrower is in default, the total amount of missed payments, penalties, and interest, a list of 5 government-approved housing counseling agencies, encouragement to take immediate steps to prevent the foreclosure, a warning that if the borrower fails to correct it, they can be foreclosed upon, a notification that the borrower has a right to remain in the home until a court order issues, and a statement that the notice is not an eviction by itself. But also, and this is the key to this case, the statute, RPAPL 1304, says that the notices must be sent in a separate envelope from any other mailing or notice. Okay? And the legislative intent here is to prevent foreclosures. So, what are our facts of our case? In 2009, Kessler took a mortgage out on a home, got a mortgage for a home, and in 2013, Kessler defaulted on that mortgage and then stopped making all payments, defaulted and never made another payment. Bank of America, who was the lender, sent out RPAPL 1304 notices with everything included that's required to be included. That's good so far. But the last page, the 7th page, had 3 additional notices. Number 1, that the notice was from a debt collector. Number 2, information if the borrower had a currently pending bankruptcy proceeding, additional information about that. And number 3, if the borrower was a military service member, additional protections. In 2017, Bank of America moved for summary judgment, saying we should win, just let's foreclose right now. And Kessler cross-moved, meaning at the same time, moved for dismissal, saying Bank of America violated 1304 of the RPAPL because they included additional notices with the RPAPL notice of 1304, and that's against the rules. The trial court said you're right and granted the dismissal, and the appellate division affirmed. It goes to the Court of Appeals, and they say no. They say RPAPL has 2 requirements: the shall include requirement, that it has to include specific language and notices, and the separate envelope requirement. They say as to the shall include, that's just a minimum. It's not a maximum. The fact that it shall include the specific notices that it lists means that it must include those, not that it can't include more. And they say, what if it said, read these notices? It's very important. That's an additional notice that's certainly shouldn't invalidate the RPAPL 1304 notice. And as to the separate envelope provision, they reject the bright line rule of saying, well, these notices and no more. And they make a point. They say, listen, this is not the only statute in the books. There's another statute called the Fair Debt Collection Practices Act, the FDCPA, which requires that if any lender, if a debt collector sends a notice to anybody, they have to include that statute. They have to include a little provision saying this is from a debt collector. That's why the first additional notice said this is from a debt collector. They said we can't, these are inconsistent rules if you apply a bright line rule. So they say The new rule we're going to adopt is this: accurate statements that further the purpose of the statute, which is to provide borrowers with information to avoid foreclosure, does not constitute other notices. So if it's an accurate statement that furthers a legislative purpose, it's not considered an other statement, an other notice. It's not going to invalidate 1304 of the RPAPL notice. But if the lender includes false, misleading, obfuscatory, which means language that will obfuscate, or unrelated information in the envelope, then the RPAPL 1304 notice can be invalidated. So that's the rule from the case of Bank of America versus Kessler. Too long, didn't read, 5 minutes or less. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.